how is spousal support calculated in Virginia? Well, let's distinguish first of all between two different types of spousal support that might be court-ordered. First of all, there's temporary or pendente lite support. This would be support that's ordered pending litigation before a final hearing can be had and the judge can hear all the evidence and testimony on the subject. Because of the great volume of cases in the court system and the limited time that the judge has for each one of those cases, the courts have often adopted formulas to allow them to make quicker calculations of temporary support. The second type of support in Virginia is permanent support. This is the type of support that would be ordered after a final hearing on the matter, either through a suit for support and maintenance in the circuit court or upon decreeing a divorce between the parties. If either of the parties asked for an award of permanent support, the judge could have a full and final hearing on that and order a particular amount of support paid to one spouse. Now, for temporary pendente lite relief, I mentioned there are formulas to calculate that. One that is in the code in the Juvenile and Domestic Relations District Court section of the Virginia Code, and it's Virginia Code section 16.1-278.17.1. There is a formula for pendente lite spousal support in proceedings in that court. The formulas are 30%, 50, and 28-58. 30% 50 means 30% of the payor spouse's gross income minus 50% of the payee spouse's gross income. So 30% of the spouse who's going to pay support minus half or 50% of the gross income of the spouse who will receive support. This applies if there are no minor children for whom support is going to be ordered. The second formula is 28-58, and this would be the formula that's used when the parties do have minor children and that support will be determined for those children. There's always a two-step process. The court would first determine if there's any spousal support owed and then determine the child support amount, because the amount of spousal support will affect the adjusted gross incomes of the parties for purposes of calculating child support. The other way that temporary or pendente lite support might be determined is according to the local rules. I mentioned this code section applies only to the juvenile and domestic relations courts in Virginia. There is no similar formula in the circuit courts, where a party might ask for temporary or pendente lite spousal support in a divorce case. The different judicial circuits and geographic areas in the Commonwealth of Virginia have come up with their own standard procedures. They're usually embodied in a set of written local rules that are available, and often these written local rules would have a pendente lite procedure along with formulas for calculating temporary spousal support. Now, in the judicial circuit in which the circuits in which I primarily practice, which are Henrico, Richmond City, and Chesterfield, those are the 12th, 13th, and 14th judicial circuits. There is a suggested guidelines or local rules for family law cases, and they have a slightly different formula for these cases. It would be a 30-30 figure without child support being paid, 30% of the payor spouse's income minus 30% of the payee spouse's income. Or if child support is to be determined or calculated by the judge, there's again the 28-58 formula. 28% of the spouse who will be paying support of his or her gross income minus 58% of the spouse's gross income who will be receiving spousal support. Now, I mentioned that the second type of spousal support in Virginia is permanent support. The classic example of this is upon decreeing a final decree of divorce, the judge might order permanent support. The first step in the process is for the judge to determine if the spouse who's asking for support is eligible to receive support. There are fault grounds for divorce in Virginia that may render a spouse ineligible for support or give the judge discretion to deny support to that spouse. And this would be a threshold issue the judge would have to address in deciding whether to award support. An example of those fault grounds, and unique among the fault grounds in Virginia, is adultery. The Virginia Code states that if the spouse is guilty of adultery, and that's the grounds in the divorce case, then the spouse shall not award spousal support to that guilty spouse unless denying the award would be a manifest injustice, looking at the parties' relative economic circumstances and the relative degree of fault that each has in the failure of the marriage. Now, general fault grounds may also be used by the judge as a threshold issue in his discretion to decide whether an award of support is justified or not. The nature, amount, and duration of the spousal support to be ordered is the second step. And the judge is required to look through a set of 13 different factors that are found in Virginia Code Section 20-107.1e. The 13th factor, in fact, is a catch-all, such other factors as the judge may choose to consider, including tax consequences to the parties. And you can find a list of those factors on my blog site, The Interplay Between Bankruptcy and Divorce Law in Virginia, if you want to see the exhaustive list, or look in the Virginia Code. These factors are to be considered by the judge in determining the nature, the amount, and the duration of support. Now, with respect to the duration of support, the term, the duration of the support that the judge will order can appear in one of three forms. Either the judge can award spousal support, permanent spousal support, for a defined duration. For instance, the husband will pay the wife X amount per month for 5 years. Or, and that's known as, it may be known as rehabilitative alimony. The classic example of this would be in a marriage where one spouse has given up the opportunity to work and advance in his or her career and depended on the other spouse for his or her support, but is able to get the training or education they need to resume their career or their work path. The money necessary to allow that spouse to do that, for instance, support to allow them to complete their college degree, might be ordered as rehabilitative support for a defined duration. The other type of term that might be ordered is for an undefined duration. This is the husband is to pay wife support of X amount per month. Now, by law, that spousal support obligation will terminate if either party dies, or if the person receiving support, the wife in this example, remarries, or if she cohabits with another person for a year in a relationship analogous to marriage, the husband in this case could apply to have that support obligation terminated. The final way that spousal support might be ordered by the judge is simply a lump sum. Husband's to pay X amount of money to the wife as spousal support. So those are the two main types of spousal support that might be ordered in Virginia. As you can hear and see, the calculations, the factors are quite complex, and you should consult with your own attorney to determine the amount of spousal support that you might receive or expect to pay in a legal proceeding in Virginia.